is my very big pleasure to introduce our panelists for today. So first and foremost, we have with us Professor Juan Fernandez Armesto. Professor Armesto is a professional arbitrator that specializes in commercial investment and construction arbitration. He has extensive experience in both Spanish domestic arbitrations as well as international arbitrations administered by bodies such as the ICCA, LCIA, VIAC, DIAC, and ad hoc arbitrations under the UNCITRAL rules. Very importantly, Professor Armesto is currently Vice President of ICCA, so we are very happy to have him today with us. Following Professor Armesto, we have Thomas Kendra. Thomas is a partner at Hogan Lovells International Arbitration Group and has extensive experience acting for companies and states in commercial and investment arbitrations and mediations. This includes, of course, arbitrations under the rules of the ICC, LCIA, ICCID, and UNCITRAL. He's focused on the industries of energy, aerospace, technology, construction, telecom, and he's dual qualified in England and France. Thomas is passionate about encouraging the growth of alternative dispute resolution, notably in Africa and also Asia, where he has worked. We are very happy to have him here with us today.
Thank you.
Last but not least, we have with us Sylvia Marroquin. Sylvia is an associate at Sheffield Lindsay in New York, focused in international commercial and investment arbitration. Sylvia has acted for corporate clients and foreign sovereigns in arbitration and litigation matters across a variety of sectors, including oil and gas, construction and infrastructure, with a focus in Latin America. She is a dual Spaniard and US citizen. That means she is also admitted to the bar in the New York State, and she has also studied in Paris and in Washington, DC. Having made these introductions, we turn now to the first part of our webinar. So what do we need to know about your first hostile cross-examination? I give our speakers the floor.
Thomas, thank you, Anna. How shall we, do you want to start? Do you want me to start? We have now some general comments on some general tips on how to prepare for your first cross-examination.
Go ahead, why don't you start us off and then we see how we go.
Okay, let me start, and you just interrupt me, Thomas, anytime you want. First of all, thank you, Sylvia, thank you, Anna, for the presentations. Thank you, Theo. It's a pleasure, and it's a pleasure seeing that so many young ICCA members are participating. We are extremely proud of young ICCA at ICCA, and it has been a smashing success. And the success is shown that so many young practitioners all over the world participate in this seminar, although it is the last day before, at least in Europe, before the holidays on a Friday. So that really shows the enthusiasm. Cross-examination. Well, you know, I'm not a fan of bullfighting, but it is a little bit the same as when the bullfighter faces the bull in order to kill him. It is the moment of truth. Would you agree with me, Thomas, that the moment of truth as counsel is, as litigator is, when you are in front of a tribunal, you have a hostile witness and you are there alone trying to get the truth or the most favorable truth out of the witness.
Absolutely. And you never know which way that bull is going to run.
Exactly. It is very similar to the bullfighter. You actually don't know whether it will try to gore you with the left or with the right horn.
Exactly.
And you get horned. Bullfighters get horned by the bulls, and lawyers, counsel, litigators get, if they are not careful, they get horned by good witnesses and good experts. So is it important? And let me tell you, yes, there is. I mean, there are a couple of moments in my professional life where I remember that really valid cross-examination, very well performed, changed the outcome of the case. I remember perfectly an English QC with 3 German scientists. It was all the German scientists, which belonged to a huge company, said that they had invented a procedure. And he, in 2 days cross-examination, showed that they basically had just copied a procedure from the claimant, from the other side. And that they had not done any inventive activity at all. And he was very, very carefully, very slowly went through it. And I came out after these 2 days, my mind totally changed. I thought he had a completely lost case, and he won. So yes, it does. A good cross-examination can change. Now, the first point to be a good cross-examination is you must know the file, and you must know it better than the witness. Thomas, would you agree with that? That if you don't know the facts, the file, every single document, you are lost.
Absolutely, absolutely. And because you're reacting, it's not like pleading. Pleading is actually a lot less stressful because you know which way it's going to go 90%. Okay, the tribunal may ask you questions that you can't predict, but you can predict many of the ways they will jump. With the witness, you can't, and you need to be ready for wherever he jumps, you can adapt and be there. Otherwise, if you can't go off script, then you're stuck.
And then that is the first point. My first recommendation is you must know the file better than the witness. And the only way to know a file is chronologically. You cannot do a good cross if you do not have a chronological index of all the documents, and you go through them chronologically. You know in your heart the chronology. To me, that is fundamental. I don't know, Thomas, if you agree with that.
Absolutely. Your cross, a bit like you're pleading, as an arbitration lawyer, your cross is to tell a story. I mean, I always see myself as a storyteller, and the tribunal is here to listen to your story, and this is your chance. And a bit like the bullfighting still, but you need to tell a coherent story that takes them through. It needs to be quite slow. It needs to be step by step. If you jump too far too quickly, then nobody will understand the middle, and you can get whatever answers you want. If nobody really is following in the room, then it won't help you. So yeah, which tends to be chronologically, because unless you're taking issues by importance, but absolutely, totally agree.
And then the other point I see, which I think is done which is one of the biggest mistakes, is you do not put yourself clear aims, clear purposes. So this witness, what do I want? He's hostile. I don't want him to repeat the story, his story, to the tribunal once more. I want that he gives me 3 elements. And we'll come that in when we go through the examination. I will draw your attention exactly. You must, before you start, you say, I want that the witness confirms this, denies this, accepts this. 3 points. And you don't have time for 27 different purposes. And it doesn't make any sense to make long lists of questions asking him about the story just for him to repeat the story from his point of view. So you must, this is to me, or the only thing, if from a fact witness, you may wish to get some facts. From an expert witness, the most dangerous bulls in the bullfighting arena are the expert witnesses. They are anyone who knows anything about bullfighting. They are Miuras. Miuras are the most aggressive and most difficult bulls there are. And experts are extremely dangerous. Because first of all, if you let them go, what they will do is they will tell their story to a tribunal which probably has not read more than the summary of their expert opinion, because I have some colleagues who have not read through every single page, believe me, and then he will just tell his story, much better articulated, much better reason, and the tribunal listening and say, that sounds really convincing. And it is on your time as a cross-examiner. So that does not make any sense. What if you want with an expert witness is either, we'll get to that. So fact witnesses. How do you get along with the fact witnesses? The point is the following. It is, I say, it is always the same. Have you ever been to Serengeti? Have you seen how the lions, it's always the female lions, by the way, how they hunt. And so they cannot, if they have the gnu there, and if the lions just jump on the gnu will just disappear and they will never catch him. What they do, and you can watch it from the Land Rover, is how some lions start closing all the loopholes where the gnu can evade. And then they slowly get closer. Then they jump, the gnu tries to run, and all the loopholes are closed, and they catch it and they eat it and give some food to the male lions who have been in the shade. And that's exactly, it's a very, very good example of how you have to do it when you examine. You have first to have an aim. The aim is to kill the gnu. The aim is that the witness tells you, the chairman of the company was present at the meeting, because that's important for you, because he has the power to bind the company. And if that is what you want the witness to say and to confirm, and there are loopholes, excuses for the witness to run away. He can say, I don't remember. I did not write it down. Or he can deny it, although it's true. And you must, of course, know that it is true. And so first, you have to close the loopholes. Ask him if he has a diary, if he makes notes of his meetings. You ask him about other meetings and who was at the other meetings. And then when you have closed the loopholes where he could escape, you get in, you ask the question, you get the right answer, and you immediately retreat. Never, ever insist. Once you have on the transcript what you wanted to have, yes, he was there, don't start, oh, so he was there for the whole meeting. And he says, no, he was there only for 5 minutes. Pah. The whole advantage you had obtained is gone. Don't give him the chance to undo. He may become aware that he has said something which is unhelpful, and he may retract. So the moment you have killed, run away. Don't stand close and say, thank you, no further questions. These are my recommendations for the fact witnesses. I don't know, Thomas, do you have something to add?
Maybe a couple of sort of tips that I have from experience as well, which potentially go against almost received knowledge, but it's things that you can start to play with it. Once you've done many cross-examinations, the first time you do it, you're probably going to be very closed questions where you know, yes, no answers, and you know the answers, and that is basically the model to follow and the best way. But there's a couple of things I would say that you can maybe start to play with, and I think it links exactly to what you were saying, in that you don't necessarily need to be only closed questions. When you think about where you go, particularly in the early parts of your script, or the early parts of a particular line of questioning, if you can open it up a bit where you think there's no risk, then you can pass all sorts of messages to the tribunal. You can show that you're not only following a script of yes, no questions for a start. So it seems more like a dialogue. So it's going to sound more truthful. And then also you get, everybody's seen the witness statement, but the witness statement was, as we know, reviewed by lawyers, doctored by lawyers, whatever. It has a certain tone. Here you will get the witness's own words. And it may be that they give you something to hang on. Now you can't only, that's where you may need, it may come after a bit of experience, but because when you get closer to your killer question, closer to you were actually at the meeting, then you don't want to start opening things up because they will just tell you whatever they want to tell you. But in the early parts, like, how do these meetings work? Who generally attends these meetings, and how do you feel about how these meetings work? So hopefully they will say positive things about how these meetings are important, they will put it in their own words. And then when you get to the he was at this meeting point, suddenly the whole meeting is very important, because we've had this introduction, this build up in their own words, and you can hang it. You can say, as you said, and then you can re-quote them back. So that's one thing, not to necessarily stay only closed, but a balance between closed and open questions. One second one, and I think all of these apply to fact witnesses more than expert witnesses, because expert witnesses, you are, as you say, fighting the bulls who've already been in the arena, and they know which way you're going to jump, and you need to be coming from a slightly different angle. A second point, at least from my experience, is don't warm them up necessarily. Don't warm up a fact witness. It's inherently a slightly unfair exercise, because we live in arbitral tribunal world, and we know what's going on, and we know how it's going to work. A bit like the bull and the bullfighter. The poor fact witness has probably never been in something like that. We'll never do it again. We'll never have some person asking him these strange list of closed questions to get to 1 point 20 questions down the line. I mean, it's a foreign world to them. And if you sort of introduce them by warming them up, like using some minor points, that might get them in. And quite often I find that after an hour or so, it starts to get very difficult to cross-examine someone, because they tend to have got the idea by then. So occasionally, if there's a big question and it's basically a yes/no question or a factual question, or you've got something relatively easy, occasionally I just ask that right at the beginning, almost the first question. Just if I want something on the record and I'm not sure I'm going to get it, I might try it, and then I might have my list of closed questions, which will get to the ultimate conclusion, whether or not they agree with me or not. It doesn't matter, because I've made the point to the tribunal. But occasionally, if I think I might just get something on the record, I just come out with it right at the beginning and see. That's worked. That worked on one big point where there was a question of whether the witness received a termination letter in time or not, and that was a crux of a lot of the case. And we had a document which suggested he did. The other side had a document which suggested he didn't. And it was literally the first question. I said, "Hello, welcome. You see this? That says you received it on this date, doesn't it? Don't you? So you did receive it on that date?" He said yes, and then we moved on. And that saved a lot of time. So of course, if he'd argued, then we could have gone into the whole thing. But that enabled me to cut out actually sort of half of my script. And what was and then the last other point it comes back to this storytelling. I always come back to the storytelling about how arbitration lawyers are storytellers, but when you're telling a story to the tribunal, and some tribunals prefer stories than others. Some tribunals prefer stories with details and with documentary references. Some of them prefer stories with emotion, and you can't always, you have to try and engage the tribunal. But in all cases, you want them to focus on the bits, on your bits. You have some bits you want them to focus on, and you can play with that a bit. So if the witness is arguing, if you know you're not going to get the answer you want, because quite often we ask a question and we know they're not going to give the answer we want, but we've gone down a path which suggests the answer, and okay, they contradict you, but you've made your point to the tribunal. But if this is an important point for you, then raise the tension, raise the tone. Don't tell the tribunal this is an important point. Now, you can't tell the tribunal it's an important point by saying, "Excuse me, Mr. Tribunal, I think this is an important point." So that's where, because you haven't got the answer you want, you might want to come back on. You don't retreat because you haven't got what you wanted. So that's where you can ham it up a bit. Is it really your testimony to the tribunal today that this and so you're underlining, despite this document, and what about this document? Is it really your testimony? It's almost, that's your showpiece. So again, it's telling the story, and then they don't agree with you, and then you shut it down and you move on. But these are bits of rhythm and style and things you can sort of play with to tell your story. So that's joining with you for the fact witnesses, definitely.
Let me jump in just to say, I think we've been covering a lot of the questions that we've received previously from participants, but just regarding exactly what you said, Thomas, we have a live question from a participant asking us, how would you handle the situation when a fact witness starts volunteering information, particularly in a virtual cross-examination? I mean, we can divide this into two different questions. What do you do if you don't have a hostile witness, a cooperative witness, or rather a very uncooperative witness that is trying to volunteer information? The two scenarios can be seen. And how about virtual cross-examination?
For my part, Well, it's very dangerous when a witness starts going off completely new information. I mean, hopefully you've read the witness statement enough times and with enough of a detailed eye to know where they might be doing that. I mean, lawyers know how to cover themselves to sort of suggest that that's possible, so it doesn't look ridiculous when the witness does it, and at the same time not to say it because they know it might not withstand cross-examination or it might not uphold. So then I'd be very interested to hear Professor Fernandez Armesto's take on that as to whether he thinks it can be convincing when a witness starts going off script, or when a lawyer, because all you can kind of do in that situation is throw up your hands and say it's not in your witness statement. But I tend to find that it's almost better to withdraw. Once they start going really new stuff, unless you have information that can contradict them, which hopefully you know the file well enough to know whether you do or you don't immediately. If you don't, then get out. They've got something ready, and then you back away.
I think that the answer to many questions is get out immediately. Get out. It is for one case you win in a cross-examination. Hostile cross-examination, you lose 50, because what you suddenly get is that a witness starts telling or a new story or something you didn't know, or that is the last thing you want. That anything a hostile witness will say is negative to your case by definition. Let me add one thing which is very, very important, and that is cross-examination only works with document production, because that is fundamental, that you have access to a full record of documents, because the witness doesn't. The witness, by definition, has either not made the effort of reading through tons of documents, or just simply had no access to it. So that is fundamental. And you must very often you must like let it fall that documents exist and that you will be drawing on documents. I would never, and I would like to know Thomas' thoughts about that. I think it tends to be much more efficient. You ask directly and then you show the documents, not show the documents beforehand, because then you direct. It is very effective, and it puts the witness in a very uncertain position. If you ask him and you say, yes, that's a good answer. By the way, this document confirms that. And then the next time you do the same, and he doesn't know if you have a document which will show the contrary to what he's saying. And that only works if there is document production. So one of the few advantages of document production, you probably all know that I'm not a fan, is that it really makes cross-examination possible.
Definitely. And it could also sometimes save you time. I mean, you don't necessarily need to go through documents. If you can get a witness to agree to something which is written in the documents anyway, then you can ask it straight out. And sometimes you can save yourself 3 documents if he just says what you want him to say. And you say, okay, great. And then you can throw those documents away and move on to the next one. Whereas if they argue, then you say, oh, okay, we're going to have to do it, and then go to the document. So definitely, it's always nice to throw in these questions off the cuff, off the bat, and then if they get it wrong, or if they're contradicted, then great. If they get it right and they say what you want them to say, then that's fine, and you carry on.
The only point for all of those who are watching us, don't do like Thomas is saying before the tribunal, take the document and throw them to the back. That's not a brilliant idea. It's a bit like in Russia, in Imperial Russia, where they threw the glasses at the war. Well, at least in movies. So more questions, Anna. I have to get my documents because I threw them back.
But it's a good point you say. Body language is so important, and similar. Don't kind of go when they give you an answer. Don't say oh right, and then give a big cross on like three pages of your questions. You like always just nod, you look calm and smile. I've had witnesses absolutely killing our case, telling us the tribunal exactly the opposite of what we wanted them to say, and you just sit there confidently. Oh yes.
there is quite a lot of psychology. To a certain extent, it is like between a bullfight and a theater. And there is an element of acting, which is important. Good cross-examinators are good actors. I mean, you somehow, the good cross-examinators, they have an empathy. They try to get some sort of empathy with the witness to get out some information from them. There is a psychological factor.
Let me jump in maybe with one more of a live question that we just received. And this has to do with civil law lawyers and lack of previous depositions. So the question specifically pertains to, you know, the general feeling of insecurity that some civil lawyers might have due to this. How to deal with this? How would you ask many questions, or would you try to structure questions to obtain what you need in a specific way? More generally, what kind of tips, how can civil lawyers prepare better for cross-examination in international arbitration?
Why don't you start off, Thomas?
I have to say, because of the way international arbitration is now with the sort of compromise between civil and common law, I don't think I've ever cross-examined a witness without having some kind of written document in advance. So there is a very different style to how cross-examination takes place between civil lawyers and common lawyers. And I think also a different way that civil law background arbitrators will expect it to take place. Often you see many more open questions, less kind of grilling down, and that can be effective. It can be very effective, even more effective than a common law sort of very closed, controlled environment. As it can also, I've seen it be completely disastrous because you just put the witness on a pedestal and he goes and says whatever he wants to say. But I've never done it with no witness statement. When you have a very short witness statement, which occasionally happens, and particularly you get the feeling it can be a strategy because the other side doesn't want you, you know, the more you have to play with in the witness statement, the more you can ask questions about, the more you'll find holes and find things. So, and then when you only have a very short witness statement, well, I think you have to be careful. You're only going to end up doing a relatively short cross-examination because it's too dangerous otherwise.
The other important thing is that witnesses, especially non-common law witnesses, they are not used to say yes and no to a question and then add any explanation they want. And that is the most, what I think for a young lawyer must be most difficult is you are 30, you have a general manager of a company who is 60, and so you ask him, were you at that meeting? And he answers, this is an excellent company which has been working for 2 decades in the field and has been an excellent, and they never answer the questions. And then it gets difficult because you want to interrupt him to say, look here, I'm not asking you about the quality of your company. If you interrupt him, then he will protest that you are interrupting him. And there is a point of, so I think that the good way to approach this is to say, thank you for your lengthy explanation. I understand you said yes, and then you gave some additional comment. And then always get him to yes and no, and try, and next time, could you please say yes at the beginning? And that is really a fight. People from common law jurisdictions are much more used. That's the way cross-examination is done also in the courts, and they will be more, will stick better to the rules. I don't know how you do that, Thomas.
No, I think you're absolutely right. And you have to try and sometimes sort of discipline the witness. There's only so many times you can do it, so you don't waste your lives. You can't spend your whole time going, you know, you just look annoying if you're always saying it. So something I have noticed is that pretty much because of the fact witness, people like to please people. I mean, we are naturally, you know, we want to have a decent relationship. So the fact witness, they're just human beings, sort of poor things. and they come in and they have this lawyer on the other side, and they want to strike up a reasonable relationship. And unfortunately, this person is a bullfighter with a sword behind his back, and but they're just they're just human, and they've not necessarily ever met this person, and they want to strike up a good relationship. So every time you tell them off, basically. So like you say, if you were looking for a yes/no question and they're refusing to give a yes/no question, then you sort of stop. You say, "This is my court. You may not have done this kind of questioning before, but really, for the purposes of the tribunal, it would be very helpful. You could just give us a yes/no answer, because that would just help everybody. Thanks very much. We really appreciate it." And stop beating around the bush. They always, because they're told off, and it's like a teacher, they go like, "The next answer is the answer you want. So don't waste your lives. But if you need one answer, then sort of tell them off a little bit before." And they always, I've seen it on both sides. I've seen other lawyers do it to my witnesses. The next answer they're going to say, "So, were you at that meeting? Yes or no?" And they will just say, "Yes." So that's just one sort of, again, psychological point, as you say. Whereas going back to my civil common law point, I had one witness with a civil law cross-examiner who left everything open, beautifully presented, and we discussed before, it looked like a perfect opportunity, and he just gave up. It was the opposite. He had to divulge everything. He just wanted to give the truth, but more than the truth, like the other side's truth. So it's not a question of whether you pin them down. It's really a question of psychology and how it's going.
Very well. I would, as a designated timekeeper, I would suggest to our panelists that for now we pause the questions that we can come back to. But I would happily introduce the second part of this webinar, where we will have a live demonstration of what a cross-examination looks like. So we will have Professor Armesto taking the place as arbitrator, Thomas taking the place of cross-examiner, and Sylvia taking the place as witness. I believe all the registrants have received the mock case on which we are basing this exercise. It is a young ICCA mock case that we have prepared for this occasion. And so we hope that this demonstration is useful for everyone, and I will interrupt you once again once time is appropriate. Good luck, and have a great demonstration.
Thank you. So now we are at the merits hearing in the arbitration conducted under the 2010 hospital arbitration rules between Ms. Sylvia Robot as claimant and Cyborg Tech PLC as respondent. We are now here for the examination of Mrs. Robot. Mrs. Robot, good afternoon to you.
Good afternoon, Mr. Arbitrator.
You are here as a witness, Ms. Robot. As a witness, you know that you have a duty to say the truth, and that you may incur in responsibility, including criminal responsibility, if you were not to adhere to the truth. Could I kindly ask you that you confirm that for the record?
I confirm.
Very good. Ms. Takendra, you are here on behalf of Cyborg Tech, of the respondent, and you want to cross-examine Ms. Marroquin. You have the floor.
Thank you very much, Mr. Chairman. Now, Ms. Robot, I'm aware that we have come across each other in our professional capacities in the past, but today, as Ms. Robot, I assume you'll be exercising, your history as the developer of Tech and Tech. Thank you very much for being here. I am, I don't know if you've been through cross-examination process before, but I'm the lawyer of the respondent in this case, and I will be asking you some questions. We would appreciate very much if, for the purposes and to save time, we only have a limited amount of time today, if you'd be able to answer just yes or no to my questions. You can, of course, give additional explanations, and it may be that your lawyers who are sitting across the table, or in this case, across the video from me, they may ask you some questions afterwards if you wish to clarify something. But just to save us time, this is our opportunity to ask questions, so I'd like to stick to yes/no answers. Now, for my first sort of thread of questions, you state in your witness statement, which we have here, I think it's at paragraph 3, that you founded Tech and Tech. So that's the company which you then sold. But you founded Tech and Tech in 2000, and you were the director and sole shareholder. Is that right?
Well, yes, to open a company in the tech industry was always a dream of mine ever since I took an interest in the field. Tech and Tech was actually this dream come true in a sense, and I worked very hard not only to achieve it, but to keep it alive after I had created it. You see, I come from quite a modest background, and
Ms. Robert, sorry, I do apologize. I'm sorry to interrupt, but just in the interest of time, our time is very limited. If you could answer my question, a yes/no answer. You said in your witness statement, I'll repeat it just to make it clear for you. You said in your witness statement that you founded Tech and Tech in 2003 and were the director and sole shareholder. Is that correct?
yes,
Thank you. Now, Tech and Tech provided cloud-based security solutions, software engineering, and data processing, correct?
yes,
Were you in charge of the decisions of Tech and Tech during this time?
yes,
Now, I assume you'd say that you'd agree with me that you were very successful in your field, is that right?
well, yes, I was even nominated for several awards.
Yes, okay. We'll get to that, and maybe your counsel will come back on it. But my point here is, did you have any experience in these type of businesses?
What do you mean by that? I have been a business owner ever since I created the company.
Oh, okay. Let me rephrase the question then. Let's say your education, your academic degree is in the tech field, correct?
Well, yes, I'm a graduate in telecommunications and software engineering from the University of Ruritania.
Okay. So, do we agree? You have no formal education in business, is that right?
Well, yes, we agree.
Okay. Now, moving on to other aspects of the case. You signed an SPA regarding Tech and Tech with Cyborg Tech on the 1st of January 2016, correct?
Yes.
So, did you assume when you contemplated this sale that it was because some external business input would help grow the company? So you've basically taken the company as far as you can, and then you choose Cyborg Tech as the buyer to take it to another level, right?
Well, of course, they did business in other markets, but in order to expand, we needed to get out there.
Exactly. So you negotiated this SPA. I mean, you must be aware that the laws of Ruritania, I think we're talking about Article 7.3 of the Code of Assets Transfer, subsection 4, paragraph 7, impose limitations on the transfer of shares, correct?
I'm not a lawyer.
Yes, that is, the witness has said what I was going to say, that she is, of course, not here as a witness and not as an expert on Ruritanian law, and she may or not have an answer, and it may or not be relevant for the case.
Thank you. Understood, Mr. Chairman. I take back my question. So, did you, Ms. Robart, did you discuss and decide on the terms of the SPA with Cyborg Tech?
Well, yes, that I did.
And so we assume you reviewed the content of the SPA before you signed it.
Yes.
Did you review Article 2 of the SPA, which talks about the consideration for the share transfer?
Article 2, no, I didn't review that article.
Yes, Ms. Robert, would you like to see the document? I mean, if Mr. Kendra, if you are asking if you will be asking, then we should show the documents to the witness so that she can follow that. Do you have the contract in front of you, Ms. Robert?
Oh, yes, well,
If I can assist, you'll find this at exhibit number 1.
Exhibit number 1. So please do, if you are going to ask questions about the document, I think it is better if the witness has the document in front of her.
So you see this, Ms. Robert, Article 2 here. Are you seriously testifying before this tribunal today that when signing a contract for the sale of your business, Tech and Tech, you did not review Article 2, so the second article, you didn't even get as far as the second article, which expresses the consideration for the sale of those shares?
well, I didn't review Article 2. I reviewed the whole SPA, but again, I'm not a lawyer.
Okay.
Well,
Now,
let me ask you that. You did, do you mean you did not review? Were you aware of Article 2? Were you aware that the consideration was 60% cash and 40% was delayed? Or were you not aware of that?
I was not aware of that.
Thank you.
thank you, Mr. Chairman. Now, according to the other terms of the SPA, you remain in your position as managing director after you sign this contract, correct?
We did. We had agreed that I would be in this position for the next 2 years.
And today you are unhappy because after this 2 years has expired, you've ultimately lost your position as managing director, correct?
Yes.
Now, was it in your functions to act as a director of business development and professional development?
Yes, that's exactly what my position was. I then went on to perform duties.
Robot, please. I've just asked you a yes/no question. I mean, was that your responsibility or not? Did you...
Mr. Kendra, let the witness, I think the witness is being rather specific in her answers. I have had to suffer much more long-winded witnesses in my life. So, Ms. Robert, do please finish your question.
Thank you, Mr. Chairman. As I was saying, I performed my duties exactly as planned. I went out and I created new business opportunities for the company.
Very well. Since you mentioned this, let's turn to the financial targets in the SPA. So back to the Article 2 again, where we were in Exhibit 1. Is that the right clause? Let me check. So excuse me, no, we're talking about Article 5 here on page 2 of the SPA, which is page 11 of your bundle. So the first condition here, it says that the buyer and the seller agree to cooperate to procure that Tech achieve the following goals and targets within 2 years from closing. And the first one is to expand the company's business in other markets, including, it's written here specifically, including North America, Africa, and China. Now, was that met?
Excuse me, I got a bit lost. Do you mind repeating your question specifically?
Of course.
It will be helpful, Ms. Robert, if you have the contract in front of you, and because it relates to an article of the contract. Would you
yes,
be kind enough to open page?
Yes, I'm pulling it up virtually now. Thank you. Can you please refer me to the clause you're referring to?
Absolutely. Article 5, paragraph 1A, and one of the first, let's say the first aim, the first goal that's listed in the contract is that there would be an expansion of the company's business in other markets. And here it's mentioned specifically North America, Africa, and China. Was the business expanded in North America, Africa, and China within the 2 years as specified here?
Well, I developed different ideas, and then the Australian opportunity came up, so I started working on that.
Ms. Robert, can you, Mr. Kendra, can you please repeat the question, because you were answering a different question. Mr. Kendra, would you be kind enough to put the question again to the witness?
Was the business developed further in other markets, including North America, Africa, and China?
Well, yes, it was. We tried.
But in your witness statement, you only focus on one development, which is actually in Australia, is it not?
Yes.
And you don't mention any frustration about North America, Africa, and China, do you?
Well, there were obstacles that appeared in achieving those goals, and the Australian opportunity came up, and as a manager, I took the decision to pursue it.
Okay. Now, you wanted to pursue this opportunity in Australia. Are you familiar with the SPA provisions on management, namely Article 3?
Yes, I believe Cyborg Tech could appoint 3 out of 5 directors of the company.
So the majority of directors are not appointed by yourself, but by the purchasers Cyborg Tech. So that means you're not in charge, doesn't it?
Well, I was the manager. I had developed different ideas, and we wanted to go with new markets now. And then, as I was saying before, we had this Australian opportunity and I pursued it. I even spoke to the Foreign Minister of Australia. I prepared ahead and I asked Cyberg about info. He never replied. So then, yeah, that's what happened.
But was it your decision to explore Australia as a potential market?
Yes.
And had you already identified Australia at the time of the negotiations of the SPA?
Yes, I believe the Australian government had made up public its disposition to invest in the cybersecurity field around December 2012.
But Ms. Robert, why is the Australian market, if that was what you had in mind, why is the Australian market not named in this Article 5? It's absolutely not mentioned anywhere in this article. Can you explain that?
Well, in the moment, I wasn't involved in the drafting. That was the lawyers were involved.
Okay, so you were not looking to develop in Australia at the time of this contract. Can't we make that conclusion?
No, that's not the conclusion I would make.
And in fact, you made an agreement that it would be in other markets that you would be expanding. That's what was written in the SPA. That's what you contracted to do. Isn't that correct?
Well, the article does, as you pointed out, mention other regions, but that doesn't mean that the Australian market was out of the question. It was a good business opportunity.
Very well. Now, do you think, in your opinion, that investment elsewhere, so you have this SPA, which is basically guiding your behavior, your management, although I understand that you say that this is just including and so could go beyond these 3 countries, but do you think that in order to do that, you would need to have approval of the board?
Well, yeah, of course, decisions had to be approved.
And was this proposal of yours to expand to Australia approved by the board?
No, it was rejected without reason.
Sorry, Mr. Robot, without reason. Can we turn to page 6 of the bundle? Sorry, Exhibit 6. Exhibit 6.
Exhibit 6 or page 6, Mr. Ken?
Excuse me, Exhibit 6, which is at page 18 of the bundle.
Page 18. Very good.
One second.
Ms. Robot, are you with us? Page 18 in the bundle.
Yes, I can see Exhibit 6. Thank you, Mr. Chairman.
Now, we can see these are the minutes of the meeting where your proposal was discussed. Can you see that?
Yes.
It's a minutes resolution of the Board of Directors, 19 June 2017. You were listed as a director present. And here, the directors do provide reasons for not engaging with Australia, like the fact that Australia was not sufficiently strategic, correct?
Well, do you think that's a valid reason?
I'm sorry, Ms. Robert, I'm asking the questions here. I can't help you on whether it's valid reason or not. I can only tell you that that's what was listed in the Board of Directors minutes. What is it that you think means that this is not a valid reason?
I mean, it was a $1 billion Australian deal. There was no other hindrances. I wrote to Cybertech and I was just left hanging dry. I had no support in the midst of a great chance. And this was all a scam to get rid of me.
Okay. Look, going back to the 3 mentioned markets, so the 3 markets mentioned in the SPA, did you actually expand business in those 3 markets?
No.
Even though you knew these were the targets listed in the SPA?
But as I said, it was a non-exclusive list. Business is always a good business.
Okay. Let's move on to another topic, a final topic before our time is up. Now, Ms. Robot, if we can now turn back to the SPA, Article 6.2. So that's your exhibit number 1 again, page 11 of the bundle, page 3 of the SPA. A bit complicated, but 6.2. It says here, the seller, so that is yourself, shall not be entitled to retain confidential information under whatever form after the termination of her functions within Tech and Tech. You see that?
Yes, I do.
Now, were you aware of this provision of the SPA?
Yes.
And isn't it the case that you retained documents such as Cybertech and Tech's plans and hiring strategy. You downloaded them on your computer, and you retained them after your position was terminated, correct?
Well, my lawyers can answer that question. The company stole from me.
Ha, now look, Miss Robot, if a person were to want to open its own new company in competition with the Tech, in competition with Cybertech, don't you agree that it would be a smart move to retain this kind of documentation?
I'm not sure I understand your question.
I put it to you, Miss Robot.
Hypothetical questions. I wonder, under the applicable rules and practices, whether hypothetical questions are really relevant. You may wish to ask the witness the purpose of why she retained that information.
Thank you, Mr. Chairman. Ms. Robot, I put it to you that you retained this information in order to start a competitive business against Tech, in order to go against the company, in order to take the consideration and then drive it into the ground. I put it to you that that's why you took this information. Isn't that correct?
Of course not, and I'm outraged by this question.
You have no plans, Ms. Robot, of restarting a company in the same line of business?
I don't think that is at issue here.
Well, it is not, but it could be a relevant question. I mean, and do you have those plans or not? I think it's an important point to discuss at this stage.
Not at this point.
But you do not exclude it in the future.
I don't exclude anything in the future.
Mr. Kendra,
Thank you, Mr. Chairman. No further questions.
Thank you. Thank you. Thank you very much, Mr. Kendra. Thank you very much for, well, in real, we would, I mean, Anna and Theo, we could have had a lawyer for the other side, for Ms. Robot's lawyer, so that it would have given more interplay to the excellent. It was very, very well done, by the way, to all of us who have heard. This is really how it happens. I mean, it is as close as you can get in a mock case to what the reality is. Thank you, Thomas. You were excellent. You were very good because you also suddenly you also punched your points against him, and it was very, very good. It was very well done. Anna, how do you want us now to proceed?
Well, I would like to ask if you have any comments that you'd like to discuss amongst yourselves about some of the questions. I mean, I was taking notes, and of course, some interactions stood out to me, also considering what we were speaking before. Of course, having a rambling witness, asking a legal question, having an Illinois cross-examiner, all of these things.
Can I ask Thomas? Thomas, why don't you tell us what you were actually looking for, and did you get it? Because I'm sure you had, like I recommended, that you have 2 or 3 purposes, and did you manage to get that what you sought?
A couple. Let's see. The first question was basically that she didn't have much experience in this kind of business. I think my questions were not necessarily very efficient, but I think I got there in the end. I think I also wanted to show that she wasn't taking seriously the contract and had knowledge of the contract, so that was a good point. I definitely got that. I wanted to make the point that she was obsessed with developing Australia, whereas the contract was to develop other markets. I think that came out fine. I made the point. She also made her point that it was only one of many markets, so it was a bit shared, but that's our case before the tribunal, so you want to put your case forward. I'm not sure. I'd say we were probably a score draw on that one. And then at the end, I wanted to suggest that that she was taking the documents for her own purpose, and then clearly that got your curiosity involved, which is always a good point. But then she gave the good answer in the end, so I think I'd say I scored the point on that one.
Sylvia, how did you feel?
I mean, Thomas came out aggressive at some point, and I mean, but that's his role. So I think it was very effective, because at some point I was put off and by some of his questions, and he got me rambling, and I think that was the effect he was looking for. You always want to make the witness look not less credible than they want to seem, and I think that was well played.
To answer my question, I think here, if you look at the documents, what really and what is being claimed in the case, what the really relevant point is whether Sylvia has breached Article 5. And to me, and of course, and the case centers on 5.1a, because then there is 5.1c. I thought that in our script, there is no reference to 5.1c. I thought that Thomas suddenly might jump to 5.1c and then put her, because we have all centered on 5.1a. That's page 11 of the bundle for everyone who's listening to us. And I thought I would have insisted more that no new contracts in North America, no new contracts in Africa, no new contracts in China, because that seems to be, she seemed to be giving that in. I would have hammered it in slightly a little bit more, because you asked at the beginning and then you came back at the end. And that is, if you have not expanded in North America, Africa, and China, well, it does not look really very good. It does not look very good as regards the compliance with this clause. You came back very nicely saying that is what good witnesses say, that saying that the whole thing was a scam, and she was able to get that through a couple of times. In real life, probably the seller of a $100 million company would have said that like 6 or 7 times, and accused someone of having instrumented the scam. The Article 2 point, of course, was a big hit. I mean, you came out as a very negligent CEO, and not having really read and have no idea of what the actual terms, and it didn't sound correct. So yes, I think it was very, very good. Anna, any more questions?
Yes, we have a couple of interesting questions popping up. Well, let me put to you 2, and we can see if we can get through all of them little by little. So one that has been quite reoccurring is one of our most recent questions that says, I've heard 1 or 2 open-ended questions. In what instances during cross-examination is that advisable, if at all? And another question I think is in the chat is, you know, what if halfway through the cross-examination the witness becomes hostile? So what are the better tips to deal with that on the side of the cross-examiner? Maybe this is something you can expand upon.
Thomas?
Definitely for the open questions, my feeling is, well, I think you want to do it when there's no risk, basically. It's good to throw some in, because it's nice to get the witness talking. It's nice to make them feel comfortable. It's nice to give some words that you may later come back to. You see what they say, and if they give you a sentence, you know, sometimes something goes, you know, they say something, it goes, bing, I'm going to come back to this one later. Now here, I think sort of purposefully, we may have gone past it quickly, but towards the end of a line of questions, where I'd basically scored my point, where I said, we had this discussion about whether it was a valid reason not to engage in Australia. And then I said, well, why do you not think it was valid to engage in Australia? A lovely open question, which gets where she basically allows her to say whatever she wants and kill my case. So that is not at the end of a line of questions where you've basically squeezed them down. That's not the time to say, now please explain your case to the tribunal. That's not where you put the open question. So that's that would be my take on that, I think. And Sylvia obviously killed me on that one.
What do you do with hostile witnesses, which become very hostile? Well, do you have any recommendation for that, Thomas?
You mean, well, hostile as in they uncooperative, or hostile as in sort of almost aggressive? I mean, if they're aggressive towards you, it doesn't look good for them. So, you know, you may almost be able to play with that a little bit and get them, you know, emphasize that sort of. Then I become the defensive one and try and make them look like the aggressor. If it's just that they're uncooperative and they're just sort of blanking you, well, there's probably not much you can do, and you're not going to get much out. You plead your case a bit. If there's a few documents you want to show to the tribunal which you haven't shown yet, then you can do it, but you're unlikely to have any fireworks.
Yes, that is also an important point you are raising here, Thomas, which is sometimes you use witnesses just to draw the attention of the tribunal to certain documents which are really case decisive. And you see how good tribunals start making notes on these documents and then insisting on having them on paper. This is why I still like to have paper bundles if possible, because in a paper bundle you can actually make a note, you can put in a yellow sticker, and you can remember that that was really a very important document. So sometimes you use witnesses only to draw the attention of the tribunal to the relevant documents, and for that even a hostile witness is quite good. That is very true. You never assume that a tribunal knows. Never assume that a tribunal has read everything, that a tribunal knows all the documents. Sometimes you find an excellent tribunal who has, but you may find that it is not always. They may have a general idea. They will have, of course, read something, but they may not remember. So it is very, very important that you lead them to the case decisive documents. That's a very good point. Sylvia, do you have anything to add?
Well, I have two questions, I guess. As a young lawyer, I have prepared cross-examinations, and I'm actually preparing for a trial in a pro bono case where I am conducting my first cross-examination. So that will be a good opportunity to put in practice the tips you've shared with us today. But as a young attorney, I wanted to ask this question that maybe other attorneys that are on the call with us share, and is, as a junior associate, when you're helping in a case to prepare a cross-examination, generally as a junior you carry the burden and the lovely weight of knowing the facts and being like in the weeds with all the documents. And sometimes it's a bit, you have that pressure, you know, of transmitting all that you know to the partner who's going to be conducting the cross-examination or the senior attorney. And what tips do you have, and what have you found helpful in your past experiences working with younger associates that you think you could share with us to make us be more effective in that process, and also to gain the skills someday to take on our own cross-examination?
You would be, let me say, I think it is a very bad, it's not a good habit when you have like an Orthodox bishop who have these, the person who goes with the Orthodox bishops at their side. It's not a very good, it doesn't make me a very good impression when you have a senior partner who knows a little bit about the case, and someone very bright, which typically is a female, sitting at his side who really knows the case. And she's trying to convey the information to him, and he's messing it up. I don't think that that is a very good either you know it yourself. I don't know, Thomas, how you feel about it. It is better for a senior partner, and of course it is not for you to give advice. But I think it is better that he really knows the facts and centers on one or two key witnesses, and then ask more junior people with maybe not so important witnesses to cut their teeth. These joint working together, whispering, you know, and it's not that document. Where's the document? Which one? 2 minutes, Mr. Chairman. 2 minutes. We have to find the document.
Yeah.
Doesn't make a good impression. Thomas, if seen from the other side of the fence.
No, I agree completely, and I think that's something we really try and do in our team is, well, we try and do it in terms of sharing around the cross-examination. Not only, I mean, it's great for the team, it's great for credit to be correct where credit's due, it's efficient because the people doing the work are the ones putting it forward. But I think it also can fit in with your case strategy, exactly as you say. You can, that's to giving the tribunal messages. You're telling the tribunal, you know, be nice with our lawyer because they're junior and they're doing their first cross-examination. So they're probably going to get an easy ride, a relatively easy ride with the tribunal. You're also telling the tribunal, this is not the number one witness. Don't get too worried about it because, well, I'm unlikely to put my most junior lawyer on the most important witness. And it just, you come across as a nicer team, I think, when it's just a senior partner and he's got people running around for him. He doesn't, as you say, it doesn't come across nice. It's just not nice. Whereas when we're passing it around between us and we're clearly working as a team, then I think it works well. So I've been lucky to be a part of that since the beginning and doing some cross-examination since very early on.
You really have to know your file. Huh? To be a very good cross-examiner, you have to know your file perfect. And when the witness says, no, that was not in March, that was in April, you say, no, wait a second, it was in March. Because do you remember that on the 22nd of March, you traveled to, and only if you know the facts better than the witness, can you actually impose your, there is an element of imposing your character, your capacity on the witness, on getting, and then extracting from him. Otherwise, if the witness is more clever than the cross-examiner, it doesn't work.
Let me jump in and ask you a couple more questions. Also, we noticed we have a participant with her hand raised. If she has any comments or questions, please feel free to add some in our Q&A. Picking up on a couple of other questions, how to deal with tribunal interference. So we had a very active arbitrator, paying very attentive. But you know, in these or in other circumstances, what to do when that happens, especially if that somewhat benefits the position that the witness is in. And a second question, it has been quite popping up. We haven't really gotten there, but it was something that indirectly came up during the demo, which was electronic production of documents. Now, my question is not specifically regarding electronic production of documents, but regarding tips in virtual cross-examinations. So I'll leave you two for now with these two questions.
I let you take the lead, Thomas.
Sorry, remind me of the first one. I noted down the second one.
It's interference by people like...
I prefer it, and I've been fortunate enough to plead before Professor Fernandez Armesto and other chairs who get involved and ask their questions. And I must say I prefer it so much because you get a feeling for what's interesting to them. And that gives you an indication for the rest of the hearing. You can work on that and develop on it. And at the end of the day, you regroup and you say, they were really interested in this point or something like that. So I'm not saying it gives an indication of their decision, but you can see what piques curiosity. And I feel like that enables you to adapt. So, and whether or not it's sort of on your side or not, because it can seem like a tribunal is asking questions that are bad for you, but it may just be that they're not on your side, but they're convinced of your case, but they are flushing out the opposite so that they can make a balanced decision. Like they need to test the theory on one side or the other. So sometimes you get an arbitrator and somebody in your team says, I can't believe they asked that question. That's a terrible question for us. And you say, no, it may be that they're convinced by what we're saying, but in order to make their award, then they need to cover both sides of the story. So I have to say, I like intervention. I sort of prefer it to the extent that arbitrators have different styles, and some really take a very backseat view. If it's helping the witness, of course, then it's a balance. So it's a temptation, particularly when you're starting out. As soon as the tribunal gets involved, or as soon as the tribunal makes a sign to you that they're not really impressed with what you're doing, you have to know when to stick up for yourself. Sometimes you have to push on anyway. You've got a point to make, and occasionally you might even make it. They may have given you indication of their first reaction, but it may not be their final reaction. So again, that's a balance. You don't want to be the most awkward lawyer in the universe, annoying everybody all the time, but you've got your points. Don't back down too early.
Yes, thank you. Let me say before, because we are running out of time, but let me say the most annoying thing a lawyer can do for me is the following. He takes the witness statement and then say, let's go to paragraph, your witness statement is page 6 or 7, I think. Here. Page 6. So let's go to paragraph 6 of your witness statement. When Cyborg Tech approached you, did you feel honored and proud that Tech and Tech was recognized as a potentially valuable asset? And they ask you what you say in the witness. And once, in order, to establish the question, but sometimes they go on and on and on, and I can already give the answer. Yes, it's what is written in the witness statement. And you have 25 lawyers, through 2 court reporters, 3 arbitrators, 2 interpreters, just that you are confirming what is in the witness statement. And exactly as obnoxious is. So let us go now to Exhibit 1. So Article 3 says, the company's board of directors shall be composed of 5 directors. Do you agree? Well, it is what it says there. I mean, how could she not agree? So one may be to establish the facts, but and this is an Anglo-Saxon perversion, but some common law lawyers, they just want to get into the record, and it gets extremely annoying. And then, as regards interference of arbitrators, provided it is not biased, and sometimes this is very unhelpful and very sad when you see winks furthering their case or furthering the case of the parties which appointed them. That I find obnoxious. And contrary to the spirit of arbitration and to the duties of arbitrators. Outside that, you must have a little bit of sorrow, a little bit of with arbitrators. They are sitting there for, say, a week, 2 weeks. Not everything which is being said is really relevant to them. So just to keep awake, sometimes you put questions because you want to be awake, or because you feel, sometimes you see that the witnesses are not answering. When I see that the witness is not answering the question, I say, no. What we wanted to know is this. Could you please answer exactly this question? Because you have more authority. And to the lawyer, sometimes they tried to avoid the answer. And sometimes when I hate also, we have some American colleagues who have a very aggressive style, because I think in US courts, it is more accepted that you have an aggressive style. So they just take on their court style into the arbitration room. And that I also don't like. I don't like, it is very stressful, as Thomas said, for a witness, that you must always remember. First of all, we are providing a service to merchants, to companies. So we have, it is like going to the private doctor. You at least expect that you will be nicely treated. So let's all be civil to each other. So I also my worst case I remember was in Rio, with a very, very, very violent US lawyer. And I had to interrupt the hearing. I said, no, gentlemen, gentle ladies, this is not going on. And let's go for a quarter of an hour. Let's take all a coffee and come back. We cannot continue. And I had, I think 2 or 3 times I had, stop it, we interrupt. Let's all go to the fresh air, because that is also not appropriate.
I remember one case where we had, it was a mixture of French law and US law. So we were helped at the hearing by some of our US colleagues, but everybody else was in a very sort of civil law situation. I remember very clearly the lawyers on the other side started their cross-examination, but in a very French way, much more discussive and open. And they said like the second question, and the US lawyers on our side, they said, objection. And then they cited whatever objection it was that they had, like some court listing thing. And everybody sort of stopped. It was like a pause. Everybody just sort of turned to them like, where do you think you are? And then they was had it sort of humored, and the chairman just about accepted it. And then they did it 2 questions later, objection. The chairman said, no, that's not going to work here. So it is, I totally agree. And I appreciate that thought of it being, it's a civil, it's private justice. We're business people. We're business people to solve a business dispute. We should do this cordially.
Yeah. Civility, being as nice as possible. We want both parties to have a good experience from arbitration, and we want both of them to get out with the sense that they were fairly treated and they got a good award and a just award, and that they repeat. Anna.
Well, before we close, I think we are almost at the time we have. Well, on my side, I would like just to, in general, thank you for joining us today. This is one of Young ICCA's main points, is to provide practical input and to continue to build up on skills for all the members that are part of this big community. And even though we can't go through all the questions, we have noted them and we've tried to put as many as we could. But we think this was an excellent exercise, be it as a theater or in lion hunting or in a bullfighting arena. We are all here to learn together. And for that, we thank you for your contributions. I give the floor to Theo for some concluding remarks.
So again, just adding on to what Anna said, we think that this webinar was quite timely and it was quite interesting for all of the participants. We did have a lot of questions on how to do cross-examination in virtual hearings, the differences between leading and non-leading questions, the distinctions between common law jurisdictions and civil law jurisdictions. And unfortunately, because of the tight time constriction, we weren't able to get through everything, but I still hope that everybody was able to get some type of quality skills training and learning and tips from this webinar. I certainly did. And we just wanted to thank you again, Sylvia, Professor, and Thomas, for participating in this webinar and assisting us and assisting our members. And we also want to thank you to our members for their continued support of Young ICCA, even in these new times with COVID-19, not being able to have physical skills training workshops, and still, waking up early in different time zones across the world to attend these webinars on a Friday, or, it may be a holiday. We're very appreciative of the support, and we hope that you continue to support us. We do have more webinars coming up. And the next webinar we have is for emerging jurisdictions on the 14th of August, 2020. More information about that is available on the Young ICCA website, and registration is open. I'm particularly excited about that because, I am based in an emerging jurisdiction, and I think it would be very useful for a lot of our members who are in the Caribbean and parts of Africa and parts of Asia are underrepresented and underserved and do not have access to the International Arbitration Center. So I hope that everyone is able to attend. And thank you again to each of you. And we look forward to working with you more in the future.
Thank you. It is fundamental what you are doing of trying to widen the scope of experience and country of origin and of arbitrators and counsel. It is fundamental. We are a private system of justice, but we want to be a system of justice, and we must encompass also all the developing countries. Africa is a huge, there is a blank space which we must, the Caribbean, parts of Asia, other parts of Asia, of course, are very much incorporated. That is not for my generation, for your generation. That is the great task of your generation, is that this is not seen as something only from white male European arbitrators, that the base of knowledge is expanded. And ICCA is doing such a great job in doing this. And I really encourage you to go on. And I encourage all those from these jurisdictions which are listening to us to take the step. Being an arbitrator is the most beautiful profession in the realm of the law. It is the culmination of it's trying to bring justice and to solve disputes, and listening, and having the privilege of having the most brilliant counsel. It's a wonderful job. It is even paid, which is amazing. I would do it even if it were not paid. And please, all of you, and we need women, we need people from Africa, we need people from the Caribbean, we need people from Asian states which are not now represented, and we need you to get on a career in arbitration and to have as your final aim becoming an arbitrator. Believe me, it is the fulfillment of a dream. So please, do all. I have a dream for you, and you should all work hard, and I will certainly support all of you to reach that dream.
Thank you. Thank you, everyone.
Thanks so much.
Have a good day.
Thank you very much.